Common delay tactics used by long-term care companies. There are 4 common delay and denial tactics utilized by long-term healthcare carriers every day, day in, day out. Slow walking, cancellation of your policy due to non-payment of your premium, misconstruing your policy and/or the facts of your claim, and post-claims underwriting. Your long-term carrier is in the business of collecting premiums, your hard-earned money used to protect your financial and personal independence. They are not in the business of paying benefits. Don't let that surprise you. So now that you understand the carrier's financial motivation, let's take a closer look at the common delay and denial tactics you'll face. Not maybe face, will face. Slow walking. Long-term insurance companies delay paying your benefits by continuing asking for additional information, duplicative information, and information that's, well, quite frankly, unnecessary. Why? Very simple. This is a game of attrition. They want to wear you out, hoping you'll give up or just forget to send in the paperwork. Worse yet, they hope that you're too sick, too disabled to fight, or that you'll die before your benefits are paid. That's cruel and heartless. They're hoping that the policyholders like you don't have friends or family members who can find a long-term care attorney who can fight for them. And the insurance company will tell you that without this additional information, they can't approve your claim. Don't believe them and don't give up. Cancellation of your policy due to non-payment of premiums. Did you know that under your policy, there's a grace period for you to bring your premium payments current? But guess what? Many long-term care insurance companies ignore their own policy provisions and even state law in their rush to cancel your policy. What happens if you have Alzheimer's or dementia that impacts your ability to remember simple things like paying your bills or your insurance premiums? You are protected under Florida law from these wrongful terminations. What happens if you can't keep up with your premium payments because of financial problems? Your policy may require that a third party, like a friend or a family member, be given notice of your non-payment of premiums before they can lawfully cancel your policy. That policy provision is called a third-party designee, and it's designed to protect you. But guess what? Many long-term care insurance companies ignore their own policy provisions and even state law in their rush to cancel your policy. Do you see a recurring theme? You can, under the right circumstances, fight to have your policy reinstated and benefits paid even when the deadlines have passed under state law or by the terms of your policy. Misconstruing your policy and/or the facts of your claim. This is a carrier favorite. It takes 2 different forms. The first is misconstruing the terms of your policy, the policy that the carrier wrote. Here are some common examples of misconstruing the terms of your policy. The long-term care services were not provided by a properly qualified professional or service provider as defined in your policy. The long-term care services provided for you are available under Medicare or some other governmental program. The long-term care services you received are not covered under your policy. Your medical condition is not covered because it's the result of a mental illness, an attempted suicide, or intentionally inflicted injury, alcoholism, drug addiction, war, or acts of war. And the carrier favorite. You have a pre-existing medical condition and are barred from getting benefits. The second carrier favorite is the many ways your carrier will misconstrue the facts of your claim. These can include you weren't hospitalized prior to needing long-term care. You didn't have an acute medical condition. You're not unable to perform your activities of daily living. The care or services are not related or are not necessary for you to carry out your activities of daily living, or are unrelated to your needs because of a cognitive impairment. You don't need the level of care you were provided. The long-term care insurance company doctor who has never examined you says you don't need the care your treating doctor says you need. And you haven't, despite repeated requests, provided sufficient verification of your need for long-term care. Post-claim underwriting. The long-term health care provider tries to avoid paying valid claims by taking a second look at how and why your policy was issued. The insurance company reasons that since you need the benefits, they must have miscalculated how much of a risk you were when they issued the policy to you. Isn't that great logic? The insurance company does an after-the-fact evaluation to fire you from your coverage. the long-term health care insurance company had all the information they needed, because when you filled out that application, you disclosed your age, your health history, and other important information. The carrier then had their underwriting department to determine if they were going to offer you insurance, for what conditions, the nature of the care that they would offer, and the premium. If you have a pre-existing medical condition, the insurance company has an obligation to investigate those facts before they offer you insurance. So let's take a look at your application. If your insurance company didn't ask for an examination, asked only if you were in good health, only asked yes or no answers to questions about your health, or didn't ask any questions about your health, it's likely the insurance company will do a post-claims underwriting investigation as part of its normal operation. If you filed a claim, part of that post-claims underwriting game is for the long-term health care company to obtain your medical records, review them, and look for a reason to deny your benefits. The insurance company is going to find some omission or inconsistency in your medical records compared to what was on your application. And guess what? The carrier is going to deny coverage on the basis of misrepresentation, concealment, or even fraud in your application. You'll get a letter that says your policy is rescinded, your premiums are refunded, and you have no coverage for your claim loss. That's not an exhaustive list, but that list is exhausting. Are you getting a real sense of the games long-term care providers play to rob you and your family of peace of mind? A long-term care attorney will anticipate all the unfair delay and deny tactics used by your insurance company and guide you through your policy, benefits, and claims process. You need an experienced attorney before you apply. A well-prepared application can prevent your claim from being denied. We'll work with you and your family so you understand what long-term care benefits your policy provides and identify the proper type of providers and facilities covered by your policy so you can make the best decision for your personal circumstances. We work with attending care professionals, functional capacity evaluators, and life care planners to document the level and type of long-term care you need. We'll also work with your doctors to properly document your care. It's a team effort. Legal help when your claim is delayed or denied.